in any custodial confinement, maybe in correctional center, or in some other cases in a police cell, or any holding facility in that regard.
Oh, you said the person who can exercise this may either be a judicial officer or an official of government. So judicial officer, I think that's pretty clear. Okay, now, maybe it's clear to some persons, or maybe clear to me, but may not be clear to other persons. So as far as judicial officers go, who exactly can exercise this? And as far as officials of government go, can anybody in government house do this as well?
No. The extant provisions of our laws in this regard would draw from the Constitution, and of course even the Administration of Criminal Justice Act or Administration of Criminal Justice Law in a state that has been domesticated. Under the Constitution, such prerogative powers, prerogative of mercy, can be exercised by the President under Section 175 of the Constitution, or the Governor under Section 212 of the Constitution of the Federal Republic of Nigeria. These are the public office holders in the executive arm I referred to that can exercise that constitutional power of prerogative of mercy, where they can go to holding facilities or maybe in correctional centers and set certain persons free who may have been convicted of certain offenses, and of course terms already pronounced by courts, or in some cases even abridge the terms, not necessarily setting the person free, but if you have to serve a lifetime, it could reduce it to 1 or 2 years and all that. Then under the Administration of Criminal Justice Law of Rivers State specifically, which is almost in the same provision in the Act, you have Section 34 that empowers the Chief Judge of the state, that is the judicial officer I referred to, who under subsection 1 has the power to visit custodial centers, prisons particularly, and then from time to time are required to also be done in at least once in every 3 months. That's what the law requires, at least once in every 3 months. And in this visit, it can carry out the exercise of freeing inmates. And then subsection 2 is in respect to chief magistrates. I think that is where perhaps the instant news item we just read directly applies, where clearly a chief magistrate can also have the approval of the chief judge to visit such correctional centers or such detention places, including police cells, and then can carry out some judicial, quasi-judicial activities in those places and could lead to setting some persons free. So that's exactly what it is with regard to the legal framework, to the Constitution, and of course the Administration of Criminal Justice Law.
Now, for the Constitution and other relevant laws to have made this prescription, I suppose that implies or means expressly it's a very important venture that should or even must be carried out by the persons so vested with such powers. Now, why is jail delivery such an important thing?
Yeah, it is important because in criminal justice system, and of course the punishment, the jurisprudence about punishment isn't quite about having people punished in the hardest form it could be. And that's why the movement is shifting towards non-custodial. So it will mean that assuming a person has actually gone through the process of criminal trial and is been convicted and is serving a term, if that deterrence is shown and then some kind of change in behavior, because it's not just expressed, even in carrying out this exercise, there could be conditions for those that may benefit from this exercise. So one of those could be some change in behavior, some have served actually even almost all the time, and some other reasons could be health grounds and all of that. So the purpose it could serve is such that such persons can actually, it's not of a merit anyway, would I say, likened to the grace. That's why it's a mercy. Such persons may benefit from that exercise of the mercy of that judicial officer or that public office holder, as we have established, to get the person out of that punishment that has already been passed on him by a court, or either to shorten the period that he would have served. So the benefit could also mean that you are you are expected to come out of to society and then show that remorse that you have shown in custody. To put it practically, let me say, the experience we have had is that some persons in correctional centers, the purpose is to correct you. The officials at the correctional center will tell you to rehabilitate you. So if a person has already shown to have been rehabilitated in a way, or the person has shown to be remorseful to his crime, and the person has shown to have also changed in behavior, those conditions may require that you don't continue to be in that correctional or holding facility, perhaps with those who have not shown that kind of change in behavior. That objective of holding persons in correctional centers for rehabilitation, they have not really changed. You pull out these individuals that have shown that change and then reintegrate them in society.
Let's talk about those. Let's talk about those in correctional facilities now.
Yes.
Does everyone in a correctional facility who has shown some remorse, irrespective of what crime they may have been accused or convicted of committing and sentenced, is everyone qualified to be considered for jail delivery?
There is no qualification in that regard as of right. I think that's why I expressed that it's likened to the great thing. It's mercy that's exercisable by the authorized officer, and then it's also discretionary. The conditions are set, and sometimes too, even when those conditions are set, it may not also be expressed as to absolute right. For instance, if the chief judge is to go for jail delivery, and then the conditions are such that all of those who are probably unwell on grounds of ill health, you may still find one or two persons who, perhaps by the degree of illness, may not succeed or may not benefit from that exercise. So you do not have a right that you could probably consider as cause of action to seek redress, that you must be. So it is not qualification in that regard. Now, but fine, those conditions that may be considered, it gives a potential benefit to all of those that are there. That's correct, if that's the angle that the question.
So how do the authorizing personnel reach these conclusions? And I'm asking this based on the following: one, they're not there at the correctional facilities. So what I'm asking in essence is, do the authorities at these correctional centers, either the prison warden or other officials there, do they play any roles, maybe an advisory role,
significantly
in determining who gets or who benefits from jail delivery?
Yes, very significant role. Every holding facility is expected to maintain a record of every individual, every inmate in that facility, and then the records are usually updated. So, of course, at every time, they have records and data to be able to provide about those inmates that fall within the conditions that either the chief judge or the president or governor may set for this time of a particular jail delivery. So if the chief judge is going for jail delivery for persons who suffer perhaps certain degree or certain kind of health challenges, the correctional officers have their records in that regard. Some is in respect to the terms they have served. So they have a record as to how long everybody has served and how long is left for the person to serve. They also have records of those who are probably, that's even more important, awaiting trial. We call them the pre-trial detainees. So in the case of pre-trial detainees, the correctional centers, the officials have records of persons who have not been convicted. So they are not there serving any term, but they are there because they are just awaiting their trial, either to commence or to be concluded. So with all of this data and information they have, they play a very critical role in the entire exercise of jail delivery. So they provide the information of all of those that qualify in this regard.
And I imagine they will also be expected to provide information as to those who may be considered to have become remorseful or reformed, considering whatever crimes they may have been convicted of.
Yes, presumably so, because they also will be consulted. It is usually a process that, like the prerogative of mercy of the governor, there is a committee that is expected to even be set up at the state level So it's expected that even in that committee, officers of the Correctional Center will constitute that committee, and then officers from the judicial arm of government.
Yeah.
So together, those kind of contribution or suggestions could come from the officers of the Correctional
No, that's
Center.
considering that there have been varying allegations of corrupt tendencies of officials at these correctional centers. Might this process not then be subjected to corrupt tendencies if the correctional center officials do have some responsibility, no matter how big or small, or some role to play in determining who gets jail delivery?
Yes, it's possible. But the only way, to the best of my knowledge, that can put a check to that kind of corrupt tendency is the quasi-judicial process that goes on there, where it is not just automatic as the list is presented to the officer, and then this authorized person would just take the list and then get the people out. In some cases, you get again where a semi kind of court setting is set up in the correctional center in that facility, where certain interrogations or questions could actually be put direct to these recommended or suggested inmates. And so that can also give an insight to the authorized.
But let's assume I'm supposed to qualify for it, and then somebody asks me to drop something, and because I'm unable to drop something, my name is omitted from the list.
Oh well, the worry here, I'm afraid I expressed that is not quite a right thing for that person to then seek redress in such a way. So that would be most unfortunate and quite a disservice to that person who is qualified. But it's generally not expected that the officers of the correctional centers should exhibit that kind of tendency. But it's not ruled out. So I wonder what direct check mechanism
delivery. But you also mentioned not just correctional centers, but any holding facilities, and this includes police stations as well. Now, how does it work with police stations?
The way the law has provided in respect to police stations, and that's particularly Section 34, subsection 2 of the Administration of Criminal Justice Act, and then law of Rivers State, is to the effect that the magistrates are also expected to be visiting designated magistrates, to be visiting facilities, cells here, police stations within their districts, that's the magisterial district. And then what they do from time to time when they visit, at least 3 times, as the courts, as the law provides, what they do there is like a mini court the same way, get there, and the same records are required under the law to be kept by every police station. Every officer, every DPO, divisional police officer of every station, is expected to keep the records of every inmate in their cell from day to day and hour to hour. Why that individual is in that custody, how long he has been, and then why is he still kept in that custody. So when the magistrate goes there, the magistrate does this interrogation and sets up as if it's a mini court session. And then we ask you, the inmate, why are you here? How long have you been here? Ask the DPO, why has this person not been granted bail? The magistrate can entertain these questions there, and where it considers that this person should be granted bail, can grant bail there. And that's the release process in course of those holding facilities. So it's just similar to what happens. During that visit, the magistrate shall inspect the records, like I said, those records that are kept about these detainees, and then can also direct the arraignment of those suspects, either there or right before that magistrate in court. So you can actually ask the holding officer, the DPO there, or any superior officer, to produce that inmate in court, perhaps just the next day, to consider why that person should not be granted bail. Otherwise, instantly and in that place, the magistrate can grant bail to a suspect where appropriate, especially if the offense for which the suspect is held in that custody is within the jurisdiction of that magistrate and also bailable.
And how do you suppose this might impact the activities of some of our officers, exuberant police officers, gallant officers, I might say, who make illegal
gallant officer.
Well, it's a fond expression. who make illegal arrests, detain persons illegally. We had the Ikoko 5 matter not too long ago, quite more recently as well. We had the case of a woman whose husband was a driver, was held for several days. He died in custody. What impact might jail delivery, and if held more frequently, have on such situations?
Well, that's why the law has become this reformative, really, because of dynamism of law. We have had situations that we never had this. If I make a brief history about the emergence of the administration of criminal justice law, and then, of course, the Act as well, it arose from serious intervention by human rights and movements and organizations that there is need for the rights of inmates to actually be considered. And then that led to these kind of provisions, so that you don't just leave detainees in police cells and in custody of police to the discretion of the police, absolutely. So the law requires certain steps and things, duties that the police are expected to perform. And of course, and the records, they are also expected to always transmit to the office of the Attorney General of a state. So failure to do so, there are sanctions, there are punishments really within the law as well. So that's the way to check the inadequacies or rather the excesses of these very gallant, in quotes, officers. Now, every police station or any arresting authority is under the duty by this law to keep the record of every suspect. Now, before now, we never used to bother about what records they keep. Now, you keep this record, and from time to time, you make reports to the office of the Honorable Attorney General of that state. And then it is in this regard, too, that the law requires the Chief Judge of a state to constitute this panel of magistrates to check the excesses of detaining officers, so that they go to their detention facilities and check from time to time, and within the period as stipulated by law, once in every 3 months, at least to close the gap, so that you don't have people who will be there for so long unlawfully. And then you ask these questions. Why is this person still in your custody? Now, the officer holding this person in custody has the responsibility to answer this question. And then the magistrate visiting has the power to release this person. And then in terms of sanction and punishment to any officer who has held an inmate unlawfully and for such a long time and without justification, beyond the punishment as it is in the Act, then of course it raises a cause of action for that detainee to enforce his or her fundamental right extantly, as against that errant officer and the police generally.
These hard facts to 91.3 Nigeria info in Harcourt, Harcourt. 169 inmates of the Port Harcourt Correctional Center have been released in the jail delivery exercise. My guest is Ekine with the Committee for the Defense of Human Rights. We're going to commercial break now. When we return, the conversation will continue, and you're welcome to join the discourse via the usual platforms. Do please stay with us. Be right back in a bit. Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your number one news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
And now, hard facts.
Hard facts with Dayo.
Welcome back. Still hard facts to 91.3 Nigeria Info here in Port Harcourt. Time died 29 minutes ago before 5 p.m. We've got the news updated 5. Before then, however, 169 now former inmates of the Port Harcourt Correctional Center very likely are planning Thanksgiving services for this weekend as they have been released. My guest is John Vivarfon to discuss the concept of jail delivery and other matters related to this development. He's with the Committee for the Defense of Human Rights, Ekine. Henry, you're welcome back.
Thank you, Tayo, for having me back.
We are live on Facebook.com/Nigeria Info PH, also live on YouTube. Just search for Nigeria Info PH. Leave a comment, we'll get to it shortly. WhatsApp is on 0809 0306416. The phone lines will be opened any minute now. But before then, Henry, do we have, considering how significant, considering how important jail delivery is, decongesting our correctional centers, which we greatly need to do right now, ensuring that people who have been corrected, who have been reformed, are released back into society, even saving people's lives so people don't suffer unnecessarily or even die in custody unnecessarily, for that matter as well. In your experience, have we been doing enough of this before now?
No, we really haven't been doing enough. Let me even first very profusely comment this number. I think in recent times, so the best of my knowledge, it does appear that it's one of the biggest numbers of release so far. I've always been unsettled when this opportunity is given, and then someone goes for jail delivery, goes and you hear is 8, 5, 9, 10 persons, and then you have a facility that was probably established for less than 1,900 and something or thereabout, and then is holding over 1,000 or nearly 2,000 inmates. Greater percentage of whom are usually pre-trial detainees awaiting trial. Then I would say we really haven't done much. I had said that if I were a governor, I think if I go, I would probably even release more than half of the detainees there. They are justified. Someone will like say, well, because those who are actually convicted and serving their terms are usually of a very significant proportion. So I wouldn't say we've done much, but we commend this one. And I hear by the report that the Honorable the Chief Judge is even going to go on another round. I think this is even the second within this short time. The Honorable the Chief Judge went there, and then a few were released for certain record issues. We heard that there was going to be this repeat. It's commendable. And then hearing that he's going to go back is further commendable. That's a good one. That's what we expect, especially in the human rights movement. But I think we need to do much more. Our worry is even more on the pretrial detainees. Why can't we even make it a deliberate policy that as I am going, I'm going to let out every pre-trial detainee? And you know who we are? These are persons who are merely there, on mere allegation of commission of an offense. There has been no trial in most cases. In some other cases, trial going on. And then in general cases, there are even persons who are on bail, and again, a mix of those who are probably yet to be granted bail. So it's worrisome that you find a Nigerian who has been alleged of commission of an offense, has been arraigned in court, and has been granted bail. But for one reason or the other, haven't been able to meet the bail condition. And unfortunately, we are not organizing our society in such a way that we have a bail bond system, that is a bail guarantee system, where either a privately arranged system or a public arranged system, where you would have had an office or an arrangement where people who are granted bail can actually get a bond from that arrangement, whether it's private sector driven or public sector driven, and then they can actually go home. So whatever the bail conditions will be, particularly the bond aspect of it, that may be forfeited to state, is not through that private arranged system or even the public arranged system. But that appears to be foreign for us here. So you now find situations where people who have been granted bail for as simple as probably little, very simple conditions, and they're unable to meet those conditions, they are in custody. And unfortunately, they probably will stay there, even with the bail granted them, until such a time as even longer than the time they would have served if the trial had gone to the end of it. Then some have not even been granted bail at all. Then some have not even been, their matters are not coming up.
Or those who have not been able to call their family people to come and bail them.
You come and bail them. So, but I always tell people by way of educating that nobody is taken to the correctional center except by an order of court. So even when the police threatens you, you go to jail, you go to jail. What it means is that they will arraign you in court. But some inmates will have interacted with a whole number of them apart from the day of arraignment. And sometimes, unfortunately, their relatives were not even aware. That's why we have a number of missing persons in this country. Not only missing persons as a result of insecurity, some are missing persons in this regard, that they've just been arraigned, and perhaps the day they were arrested, and the police just arraigned them probably very quickly, and then they are remanded. No return to court. So no opportunity to even be granted bail. These are very disturbing experiences. And then the inmates, for me, in these categories, should be taken home.
Well,
you arraign someone and then you're not prosecuting him. Even the state, sometimes you have people who are in custody awaiting the opinion of the DPP, and then it takes months and years for a simple opinion, whether there's a prima facie case or not, from the Department of Public Prosecution in the Ministry of Justice, and then somebody is there. Can I tell you just for a moment, another very disturbing, very worrisome experience, that we will be in court, and the state council will be telling the judge or the magistrate that I can't find the file, but someone is in custody, but you can't simply find the file of a person whose liberty has been denied him. If I were a judge on judicial activism, I would have been to go home. But otherwise, then we need to really look back.
Henry, we must move on right now. Before I go straight to the phone lines, I must ask you this as well. Does jail delivery pose any threat at all to the security, the general and overall security of society?
It isn't expected to pose any security threat, but if it is perverse, then yes, it's a very big threat. And what do I mean? Like we agreed, if the conditions are appropriate, then one of the conditions to benefit from this exercise would have been that you've been remorseful, you've been repentant, you have been rehabilitated, which is the primary responsibility of the correctional center, to rehabilitate. So it's not expected that you would have come out to be a threat, but of course you would have come out to be productive, and you would have come out to reintegrate in society. But with experience, sometimes when this process is perverse, we even fear and worry, especially when politicians are the ones driving it very seriously. There are some unwholesome objectives of doing this. Some have argued that it's perhaps when they want to get some of their own that have been held and detained to come back to probably their unwholesome operations. So that is the angle that may be a threat to security in society. Otherwise, the primary objective or expectation would have been positive, not negative. But where it's perverse, and where perhaps you have, let's be very frank here, maybe you have some thugs or some cultists or some criminally minded persons who have actually been apprehended and arraigned. Unfortunately, so perhaps maybe the circumstances were such that their godfathers could not have protected them. Then the roundabout way would have been to probably carry out this kind of exercise, and then they identify those ones and feed them, and then they come out to become greater threats to society.
All right, join the conversation right now. The lines are open. 0817-923-0002, 0817-923-0003, 0817-923-0007. We're live on Facebook.com/Nigerian for PH. WhatsApp on 0809-030-64169. Now, Henry, very quick one. Just a while ago, you said if you were governor, you would release more persons. Are you considering running for office someday?
When I'm considering what?
Are you considering running for office someday?
I would not say no, but that's not my aspiration. I would rather remain here and then talk to our people and then make sure that I do the much I can to enlighten people. With the perverse system we have in politics, I'm afraid that I don't want to be tempted to rather go against my people. If given the opportunity and I get there, I think I would protect their interests.
Noted, and we'll go to Ikechi from Transmadila. Ikechi, you're welcome. Go ahead.
Hello, Dayo. Good evening.
Hi, go ahead.
You see, I want to ask, who is supposed to enforce this law? Because it's supposed
Ikechi, our entire conversation so far has answered this question.
Maybe I didn't get that. Maybe I didn't get from that point. Because why I'm asking this, from all what he has explained, frankly speaking, if this thing has been done, we will have most people in the prison. Likewise, the cell. All guys, oh my God, the guys are languishing in that cell. And the magistrate and the chief judge, they know what they're supposed to do, and they're not doing it. And all of us, we are just keeping quiet. Who's supposed to enforce it? Who's supposed to make sure that these people are doing it?
So, Kechi, just to answer that question very quickly, the people who've got the responsibility to enforce it, we've got the chief judge of the state, and then the governor of the state also is saddled with the power to carry out jail delivery or pardoning even convicted felons as well. Via WhatsApp, Dan, for clarification purpose, please, did he say that the magistrate will take permission or approval from a judge before exercising such rights? Abreu Kinsley sent that in. Could you clarify that for this person, Henry?
No. The magistrate already designated and constituting that panel does not need to further seek the permission of the chief judge to go to those holding facilities within the district to carry out that function. No, it doesn't. All you need, you are a chief magistrate already. That's the authority you have. That's the qualification you have. Then secondly, constituting that panel. That's all you need. You don't need the permission of the chief judge to go to those cells and holding facilities to carry out your functions. No.
All right. Okay. We go to Ezra from Eagle Island. Hi, go ahead.
Yeah, good evening.
Hello, go ahead.
Well, I think to me, I comment what the chief judge done, and I still want him to do more, as he says. But my question is that what can be done to stop this illegal arrest from police? Because most of these people that found themselves there is because of police attitude. So to me, I want to ask again that what can be done Ezra,
the issue of illegal arrest, Ezra, if you listen to it, the issue of illegal arrest really is not within the scope of what's being discussed at the moment. We're discussing jail delivery. I think I'll just leave it at that. It's not really within the scope of what's being discussed at the moment. And via WhatsApp, good evening, Dio and Mr. Ekine. We have a situation where state chief judges, state attorney generals, and the magistrates are all not doing what they're mandated by the Administration of Criminal Justice Act 2015, all of which, in my opinion, constitutes dereliction of duty or even criminal negligence. In the case of the chief judges and magistrates, is it possible to report or petition them to the NJC for punitive action or State Judicial Service Commission for the state and federal attorney general who are lawyers? Doesn't this negligence of duty constitute professional misconduct which NBA should consider disciplining its erring members? That's in text. Henry?
Yes. It's possible, but let's start with even an action for mandamus. This is an extant law made by the states or the act enacted by the National Assembly. And like every other law, an infraction or disobedience of it is condemnable, and then there is a provision for punishment in that regard. For the judicial officers here under this law, it's a public duty. It is that the chief judge must designate the magistrates. At some point, the Committee for the Defense of Human Rights in Rivers State, we had written, in fact, there was a mandate by the National Executive Committee of the CDHR from the Rights House in Ikeja to all state branches to write to chief judges of all the states to give to this provision in the states that had domesticated this law. So we wrote to the Chief Judge of Rivers State, and that should be the former Chief Judge, and then we demanded that this designation of magistrates be done. So that's one of the steps that you needed to take. And then failure to do so, you can approach the courts for an order of mandamus, that is a public officer having a legal statutory duty to perform and fails to perform that duty, that the court should mandate the person to perform that duty. It's as simple as that. But otherwise, the neglect has been there. But there are states that constituted, after we wrote, there are states that constituted the panel. They even included some members of the Committee of Defense of Human Rights, and then even some other members of other civil society organizations in those panels. Now, outside that, you can also, on side of the detaining officers, the law is extant that such police officer would come under the police regulations and also can be disciplined by the disciplinary procedure as prescribed in that provision. So meaning that where the police officer or the DPO is supposed to provide those records and then is not providing to the magistrates where they are designated, it's like I said, that section 34, subsection 5, clearly also provides a situation of default by any officer. But are we doing that? Is another question. Then you can petition to the NJC for possible disciplinary measures by the NJC for a chief judge who consistently refuses to constitute or to designate the magistrates to do that. I think that's also probably a window that can be explored.
We got Chuksel from Rupaku. Hello, Chuksel.
Good afternoon.
Go ahead.
You see, one of the problems that is bedefiling our criminal justice system is our judges and magistrates. They are seemingly reluctant to apply the innovations brought in by the criminal justice law. You know, for instance, Section 32, even Section 30 of the ACJL. You know, if somebody is detained beyond the hour required by law, and you approach a magistrate for an order to order the detaining officer to produce that person in court, the process of filing that motion itself is a problem, because you can hardly file a motion within a day or two, and the matter gets listed before the magistrate court to hear you. That's the problem we're having. So if magistrate can be proactive enough, you know, to set up a system where you can go to court and file that motion that will enable the magistrate to clear the matter and then make an order to require that the person be produced before the court, or to show reason why the person is not granted bail, or even grant bail to the person. Those provisions are in the practical implementation is a problem. That's the problem. I've tried this several times. It didn't work, because when you go to court to file, it will take weeks before you even get it to be listed. Such a magistrate to be had. That's the problem.
All right, just good to hear from you. Henry, would you want to weigh in on that?
That's the position. Those are the challenges we also even really have. Because we have said it really, the extant laws are to the effect that there is even the power of the judicial officer to release a person on bail even before charge, even before accepting the charge. And then where, again, a person has been detained, all the relatives of that detainee need to do is not to troop there to the police station, and then you begin to have opportunities of negotiation with the police. Go to a lawyer, do the necessary application to the magistrate within that district. And it is required and expected that the magistrate should call for the production of that person and grant him bail. But the challenge is what I believe my colleague had just said. That's it. That's the challenge. You will do this application, and sometimes, I think for me, the requirement of what is lacking here is judicial activism. Because the magistrates are empowered to even inquire into charges before even accepting the charges. You can't arraign or attempt to arraign a person and you walk that person into my court if I'm a magistrate, and then the person is bleeding profusely, and I am seeing that right in my face, and then the person is limping into my court, and the police officer is bringing the person for arraignment, and I will not inquire and ask you, why are you bringing this person bleeding profusely to my court for arraignment? And then probably you are even on your charge alleging an offense that if I follow the fact that I don't have the jurisdiction to entertain it, then I remand this person in that condition. That's why the advancement in this Administration of Criminal Justice Act and law empowers the magistrate to make an inquiry immediately. And some of us have been requesting that that inquiry be made. I have had not less than 3 to 5 instances that the magistrate has made those inquiries, and in most cases the charges have been withdrawn because the truth will come out there, and then such persons will either be granted bail or that charge will be amended or even withdrawn. So judicial activism is required on the side of the bench, the lower bench, and even the courts of record. Then also our own colleagues at the bar, I think we need to also up our action. We are defenders of the common citizens, particularly those who have been oppressed. And of course, we are ministers in the temple of justice.
But if you come into via Facebook, Giadam Gotson goes, good evening. I feel jail delivery hasn't been carried out enough across the nation. So unfortunately that justice has been denied and not been accessed by several inmates across the country. I commend the Chief Judge and urge him to do more. Still via Facebook, Stanley Martins goes to welcome development, and also Wele Chinedu Maduba goes, what leads to the congestion of the prison stems from holding charges. The police, rather than charge suspects to the courts that have the requisite jurisdiction to try them, they just rush them to the magistrate's court that lacks the jurisdiction, and the magistrate has no option but to decline jurisdiction and order their remand. We need to change this way of commencing criminal trials. If holding charges are declared illegal, prisons will see lesser number of persons. Henry, what's your take on this?
Yes, that also had been a challenge, but I think the Administration of Criminal Justice Act has also taken a step to address that. If there is a charge before a magistrate's court who ordinarily would lack jurisdiction to entertain the charge on the face of it, you still have the power. The Act has empowered the magistrate to make inquiry into it. So the tradition of holding charge, where you just would say, I do not have jurisdiction, and then you just remand, but then you have the jurisdiction to make the order of remand. I think that has also been addressed under the Act very, very considerably.
All right, and back to WhatsApp once again. Out of curiosity, these illegal or undocumented detainees are not officially enrolled in the prison system. I wonder how the Nigerian Prison Service or the police get funding to feed these illegal detainees. Let's talk about that for a bit, not the feeding part. Obviously, they're not being fed. Talking about, you have instances where people have been arrested for sometimes the most ridiculous of reasons, and they're being held in police cells across the state or across the nation. And then somehow the matter blows up or inquiries are made, and you have even the DPO of the station feigning ignorance and claiming to not know that such a person is in their holding facility. So if a magistrate were to go to such a place, for example, and the presence of such individuals is even a secret of sorts, how would this help such persons?
Hello?
Yes, Henry.
Yes, sorry, I didn't get that.
All right. You have cases where people are being arrested and are being held in prison cells, or pardon me, in police stations, in holding facilities in police stations, and you have DPOs of some of these police stations even claiming or feigning ignorance of the presence of these persons in their holding facilities. When magistrates might go to such places to carry out these activities, how will those persons, be helped when even their presence in those holding facilities are being denied?
Well, and that's the reason every police or any officer in charge of a police station is expected to maintain a record of every person arrested and detained in that police station. So if you have that record, it is just absurd that you would deny that a person is within your custody. The era we have had that denial was the time that you usually would not have this record, and then there was no mandate of that police officer to produce this record to the magistrate, and then you just go and say, I'm looking for a certain Mr. B, and then they tell you, oh, he's not in our custody. In some cases, while he is actually there. So the requirement that these records must be made available and submitted to the Office of the Honorable Attorney General is to put a check to this. So that at all times it is expected that every inmate or every person held in custody in a police station situation should be on that record. So when the magistrate comes and demands for the production of that record, it must be produced. That's the first instance. Any default or any failure to produce, of course, we make that officer subject to the disciplinary procedure under the police regulation and under the police act. So I think that if followed very committedly, as it is in the administration of criminal justice law, we should begin to have a situation where that kind of excuse should be diminishing, and probably even expect that it should be out of any excuse by any police divisional officer, really.
So I imagine we should expect, as has been cited on the news item, that a lot more of this will happen in the coming days and weeks. Well, on that note, we have to wrap up the conversation. Thanks for joining us, especially my guest, Henry Ekine, as a lawyer, who is also National Publicity Secretary with the Committee for the Defense of Human Rights. Henry, many thanks for your time.
Yes, thank you very much, Dayo. Could you just give me like 1 minute, please? Dayo, the point we made, which is very important for our people, our listeners to hear, is that Section 300 to 301 of the Administration of Criminal Justice Act is where we said if a magistrate is having a charge that seems to be outside of this jurisdiction, still has the power to consider whether there's a reasonable cause to order that a suspect be remanded, or even if it does not agree that there's a reasonable cause, despite the charge on that charge before the court can also still order that the person be released. And lawyers need to emphasize on this as a matter of fact.
All right. Well,
thank you
once
very
again,
much.
thank you for your time.
Yes, please.
On a commercial break right now. We got the news update coming on top of the hour at 5 o'clock. After that, Gombe State is asking Lagos and Rivers State to be their brother's keeper. Let the federal government keep collecting VAT because they may not survive if this situation continues along this trajectory. Should Lagos and Rivers State be their brother's keepers? When I return, please stay with us.